Clarice. Eu trabalho aqui no Ministério da Justiça, no gabinete do ministro. O que eu gostaria de saber, que me intrigou bastante escutando a exposição, a respeito das técnicas metodológicas, especialmente quando, de maneira mais massiva, quando você trabalha com grandes massas de dados, como um grande desafio para a gente hoje é discutir, do ponto de vista empírico, a elaboração dessas pesquisas relacionadas, especialmente essa discussão sobre uma política de luta pelos direitos de uma maneira mais individualizada ou mais coletiva, quando você fala do class action. Então, no momento em que você trabalhou, por exemplo, esses dados comparando o uso maior de demandas individualizadas versus o class action, que não existe no Brasil exatamente isso, mas seria alguma coisa próxima da nossa ação civil pública. A gente tem algumas figuras de demandas coletivas não idênticas ao class action, mas parecidas. Queria saber como é que você tratou esses dados, como é que são as técnicas metodológicas para a coleta e tratamento desses dados. Obrigada.
Thank you. It's a great question, and I tried to sort of do an overview of the whole project, and that might be a little overwhelming. But at root, what the title of the book is Rights on Trial. And this is exactly the kind of question we're trying to answer. So how, when you've looked at it from all of these different, using all of these different methodologies and from all of these different perspectives, can you get a consistent story about law and particularly the court's capacity for social change? And we do see the dramatic effect of social rights. So the original idea of the EEOC was that they would take these group claims on behalf of a society that wanted to remedy its legacy of legally enforced racial discrimination. And that agency has largely been is ineffective. It's a big ineffective bureaucracy with a large backlog of cases. And so there are 3 authors of this book, and I don't know if you guys have these books here, but in the U.S., in English, we have these books that kids read when they're like 12, and you choose what the person is going to do next in the book. So if the person, goes left, you turn to this page, and if the so you choose your own story. And so we talk about, with this book, having a choose your own story ending, because all 3 of us we sort of disagree about, I don't think dramatically disagree, but we disagree a little bit on what it says. I think it shows that this kind of model for social change is not effective, despite some successes and some gratification on plaintiffs' parts that the state is trying to do something about employment discrimination. But fundamentally, I don't believe that these financial costs are significant enough for business to fundamentally change their practice. Now, if you say that, then the newspaper says, these scholars of race discrimination think there should be no system of civil rights. No, I think that we might be looking the wrong place when we're asking one individual to sue a large company, especially with, and this is just too complicated to go into in the talk, but the way that attorneys' fees are structured in the United States, there's almost no incentive for people to be plaintiffs' lawyers. So we've messed up the economic incentives for these people to get public interest, or to get good legal representation, and that's the big thing that happens. We've defunded our main system of public legal services. The Legal Services Corporation in the United States is massively defunded. And so in addition to the struggles inherent in proving a discrimination claim, we have these structural economic rules and incentives that make it very hard for anyone to get adequate representation. So I would argue it doesn't work. Bob Nielsen is more on the side of, it might not be working in court, but the threat of invoking this system is having some effect in workplaces. I think it's hard to know. Right, so you're asking me, really, am I an optimist or a pessimist? How I split them up at the beginning. I think I'm a pessimist for this model. I'm not saying the state shouldn't have any role in trying to remedy racial inequality. But this model, I think, is inherently problematic.
There was a question about how you go about, dealing with the data for the quantitative.
Oh, well, this project has had
given a massive...
so many collaborators. So the EEOC, who is really paranoid. I mean, paranoid is the only word I can think of about people getting these data. So we can have it on one computer that is never, ever connected to the internet. So this state agency has given us this data with 1.6 million observations, which under normal circumstances, you would hire a statistical expert to help you, and you would email it to them or upload it to Dropbox, or you would figure out a way to get it to them. No, we've actually had to bring our consultants in to sit in a room to analyze. So those are the biggest restrictions are on the EEOC data. And we can't share it with anyone. I just went to lunch with somebody the other day who the whole point of the lunch was at the end to say, can I use those data? And I said, you have to get permission from the EEOC. The filings case study is easier to manage because that's all based on public records, but it was very hard to do. So all cases are, they're kept in federal record centers all over the country. So we had an electronic file of the docket numbers, and we drew the random sample in the 7 cities. But then you have to go to the city, and you go to a building not as pretty as this, but kind of like this, and you check them out of a library. We could not bring computers. Some of them, you couldn't bring pencils, right? Because the carbon, right, these are centers where the records are trying to be protected, so they don't like the carbon fibers or whatever. And so this was a survey that was taken on paper by people who went and, so we had research assistants move to these cities for like a month, lived in Kansas City, lived in Boston, lived in, and would go in and fill it out on paper, and then we double coded it, and now it's all neatly in Stata for anyone to play with. But it's a massive undertaking, so they had to mail these things back to us. The survey instrument is 9 pages long. On the back of one of the pages, so one of the variables is the size of the file, so like literally so on the back of one side, there's a photocopy of a ruler, and they're measuring with the back of the paper. So it was a pretty complicated data collection.
Eu integro grupo de pesquisa na Universidade de Brasília, de criminologia crítica. A gente tem trabalhado muito com pesquisa empírica e com foco bastante na questão do direito da linguagem ou do discurso de atores jurídicos, no caso de juízes. Então, eu queria ouvir de você um pouco mais sobre... eu sei que nos Estados Unidos é muito forte uma linha de pesquisa de direito e linguagem muito mais de Chomsky do que a vertente mais francesa de análise do discurso. Mas a gente é muito interessante a pesquisa empírica para notar, então, falas, repetições de discursos que se evidenciam, então, rastros ideológicos, de pensamentos ideológicos. Então, a gente percebe muito uma repetição de formas de julgar, repetição de justificativa de decisões. Então, eu queria que você um pouco abordasse isso assim. Eu sei que os nossos sistemas judiciais são bem diversos, mas como é que essa questão da linguagem, nas suas pesquisas, como é que vocês trabalham a questão de ideologia e linguagem?
Okay. Thank you. That's a terrific question. Thank you. I'm very interested in this. My first research project was about how ordinary people understand the First Amendment, which is free speech in the U.S. And so it was very much a big, grand theoretical, grand constitutional right on which our country was founded. And I was talking to ordinary people, some with no college education, many with no college education, and certainly no legal education. And that was exactly what I was looking at. How do they talk about it? How do they understand it? So I think one of the things that we see in this employment civil rights case is this idea that I read from this judge, the law doesn't guarantee a fair outcome. That's the most repeated trope in employment civil rights cases. We're not a superhuman resources department. We can't guarantee fairness. We can't solve all of your workplace problems. We can only solve this one very limited thing that is extremely difficult to prove. And so, sorry. I think that's the most common trope in the cases, but then in the media, the common trope is about greedy plaintiffs, right? They're lazy, they're unproductive, and of course, this is fueled by research institutes funded by business corporations to further their goals, right? In some ways, so we have, there are a few, there are government and nonprofit and university institutes, but we have the Heritage Foundation, the Liberty Fund, right? There's quite a PR arm of business that's making the argument, look, there's no discrimination anymore, and these laws are just sort of a drag on economic productivity. And so that is, I would say that's the prevailing view among people, even unless you can sort of get them around to getting their head around the idea that 2% of these cases are going, 6% of cases are going to trial. And what I didn't, the EEOC had about, over that time, like 15 to 20,000 cases per year. In federal court, you have, or is that federal? You have about 8,000. So there's this massive drop-off. If you think about it in socio-legal terms of the pyramid of disputes, right, with here are people who think they've been discriminated against, only some of them make it up to this level and to the EEOC, and only some of those make it to federal court, and only some of those make it to trial. It's not a pyramid. This system is a toothpick on a battleship. I mean, this isn't a dispute pyramid at all. So those are the common claims that are made about this kind of litigation.
Nos Estados Unidos tem uma tradição muito forte, na verdade, de estudos sobre, como ela colocou aqui, consciência jurídica, né? Que são os estudos que acabam abordando mais a questão do discurso, como as pessoas enunciam, né, e articulam suas compreensões do direito. E aí tem um livro importante de uma pessoa que eu estou citando aqui, estou falando tudo isso porque ela, né, deve ser uma das colaboradoras da nossa rede. Nós quase conseguimos trazê-la para o Brasil ano passado, que é a professora Elizabeth Mertz, que tem um livro que chama The Language of Law School, em que ela analisa o papel do discurso na estruturação da consciência dos estudantes sobre direito, especialmente no âmbito de cursos de direito dos contratos. Então, é uma pessoa que possivelmente a gente vai ter aqui no Brasil, né, talvez ano que vem, e que tem um livro, esse livro realmente é precioso em termos de analisar, né, discurso e componentes ideológicos de discursos jurídicos, né? Em sala de aula, no caso, que ainda torna mais fascinante, né?
Hi, I wanted to go back what you were saying about...
Wait, who's talking?
Me here.
Go like this. Okay, thank
Hi.
you.
I wanted to ask you something, going back to what you were saying about how it's difficult to prove discrimination in terms of evidence. And just as a disclaimer, my own research, I work with litigation as well, but workplace bullying cases. So I get also a big component of discrimination, but here in Brazil. And I wanted to ask you, because I had a similar result in my own research, that a lot of judges and even the other party's lawyers, they say the same thing. This case is weak, is only based on witness evidence. We don't have, it's not really discrimination, or this really didn't happen. Because sometimes it's like one witness from the plaintiff side would say, oh yes, I'm his colleague or her colleague, this really happened. And then a manager or supervisor from the other side, oh no, it's not such a big deal, I didn't say it that way, it was a joke. Because also there's a cultural difference here in Brazil, where we have, as a culture, people make more jokes, and sometimes maybe a person wouldn't say such a direct racial slur, but they make racist jokes or sexist jokes as well. So I wanted to ask you, I think that's a big problem for us studying litigation of discrimination cases. What can be done to solve something like that, like legally, for the plaintiffs? Because it's really difficult to win a case based on discrimination. Because what other resource could you use outside of asking for a colleague or someone who happened to know the situation come and be a witness? I think it's a real challenge for us working in this field.
Yeah, I think so too. I mean, I agree with you, and I would add to that also the hierarchical difference between this person being bullied and the school or the workplace, or who has a lot more resources in socio-legal terms. They're a repeat player. They already know who their lawyer is going to be and all of those things. But I think this is the big question. Do we continue to pass statutes that give people the right to sue, or do we begin to pursue some other kinds of mechanisms to produce racial equality, right? Do we begin to think about, I mean, it's not going to happen in the United States, and I know it's very divided here, but different systems of affirmative action in as early as early education, not just at the college level, but can we be investing in more human capital? Are we spending resources over here in litigation that would be better spent in some other way to try to promote? I was saying earlier, Norway, there's just beginning to be empirical research. Now, Norway is pretty homogenous. But they, based on their gender quotas, if your company is publicly traded in Norway, you have to have a certain number of women on your board of directors. And now that's a trickle-down theory of gender equity, right? So if you have women on your board of directors, how is that really going to help your line workers in the factory? I don't know. There's just beginning to be a few years worth of empirical research to begin to look at it. Germany's considering it. But I think, given what we know about the litigation, this is very unsatisfying for a lawyer, I know, but given what we know about the litigation system, I'm not sure continuing to pass laws where we pit individuals against major corporations is the way to achieve these social goals.
Or even against the public, even within the public sector as well. Yeah. I agree. Even against the government.
Government is its own, exactly.
No, I agree, because especially in workplace bullying cases where it's all about the organization of the labor force, which is leaves room for lots of discrimination and other things that can be harmful to the health of workers. Yeah.
And in a big class action lawsuit in the U.S. was against Sears Roebuck, like 30 years ago. The Sears defense was, of course we pay women less. The census data show that women earn less, and we're just keeping up with the market. And the court bought that defense, right?
Sue the market then.
Yeah, economics. So this may, I think I definitely would argue against continuing to, and we're doing this in the U.S. right now with gay rights. Like, everything is proceeding exactly on this. We did it with disability. And now we're going to do it with, and we're just going to continue to grant this set of rights that looks like what was earned through the civil rights movement, which had its own historical it had its own history, it had its own actors. There was law, there was segregation enforced by law. It's really different in these other areas. And I think to just continue to say, here's what we give you once we recognize that your group is disadvantaged. We give you this set of tools. This set of tools is hard to work with.
Bom dia a todos e todas. Sou Ana Gabriela, estou coordenando uma pesquisa em andamento do Pensando, Direito sobre maternidade e prisão. A minha pergunta é no sentido da metodologia, principalmente inspirada na leitura do seu texto em relação a multimétodos, etc., diversas perspectivas. Então, pelo que eu entendi, você utilizou a entrevista dessas diversas perspectivas, entrevistas com, né, advogado de acusação de defesa, com as partes. E aqui curiosa em relação aos juízes e jurados, né? Se chegou a ter essa perspectiva de quem eram os jurados, né, do perfil deles, até a curiosidade de como que é o acesso, né, à publicidade ao pesquisador, né, dos debates, que imagino que os debates entre jurados ocorrem em âmbito privado, do qual o pesquisador não tem acesso, então essa é uma das questões. E ligado a isso, né, se também, pelo que a gente você pegou casos que já ocorreram, né, mas pensar na perspectiva também de etnografia desses julgamentos, né, se vocês pensaram, isso foi um método utilizado. E pensando nisso, né, o que eu tenho percebido, até com uma outra pesquisa que eu coordeno, é pensar se o impacto do pesquisador e do público nos julgamentos, né? Porque o que eu tenho reparado é que às vezes, pelo menos aqui no Brasil, né, o júri, que é a nossa forma de julgamento, vamos dizer, né, mais público. Então, que na presença dos pesquisadores e do público, isso acaba, né, se relacionando e alterando a própria percepção e os discursos, né? Então, se tem esse potencial da pesquisa empírica dentro das cortes. Obrigada.
Okay, those are many good questions. Thank you. So one of the papers that was very early on in this project, I didn't present anything from it, was an empirical, and this was really to just start to get our traction on what is going on in employment, in how the public understands employment civil rights. So we did a national random sample of newspaper and television news reports of employment discrimination lawsuits, and it's a fascinating paper. I wrote it, so that sounds immodest, but it was all I did was track what was actually happening out there. So we modeled this research after Michael McCann's analysis of media on tort law, and so we just plopped his methodology into civil rights litigation, and we compared media accounts of civil rights lawsuits to the district court outcomes. And so we did it, and the media presents such a skewed version of what's happening in the courtrooms, right? So the media, and that's what the media does. They're supposed to, talk about news, what's different, right? If everything's chugging along how it normally chugs along, that's not news. It's news when somebody sues Chevron for $20 million or 20 billion, right? So you get this huge effect for the big cases, painting a picture for your jury pool, and frankly your judges too, about what's happening in these cases. So we did that. We took all these media accounts. Where's George? I'm sorry, I'm bashing on the media, George. Okay. And then we threw out every multiple account of any case. So like the McDonald's coffee case, right? That was news everywhere. It's not a civil rights case, but that was in every newspaper. So if there was any duplicate reporting, we threw out the duplicates. And still the average lawsuit so if you pick up a newspaper in the United States, 90% of the time, if there's an article about employment civil rights, 90% of the time you're reading about a victorious plaintiff. And the average lawsuit you're hearing is 1.2 million. Our plaintiffs won 2% of the time, and the average compensation and settlement is $30,000. So it's tremendous. And so then it remained so skewed. We threw out every media account that had, so first we threw out multiple accounts, but we left one for each case in. Then we took out even that one. So making the strongest argument against that the media is massively skewed, we still have this $30,000 to 1 million. So I think you're right that people don't really understand what's going on. And I think that they don't really understand that there are 2 points to litigation. Well, there are many points to litigation, but there are 2 that are kind of competing. And one is for the person to be compensated for what happened to them. So if you're treated in a racist manner, like what do you deserve? But then there's also this question of how much can we make this cost the business so that they will change their behavior? That's the model whereby this works, or the prison changes their behavior, or whatever it is that you're studying, right? It has to cost that company, that prison, that government enough money that they're willing to stand up and take notice. So you can end up with this big disparity where if a company has a history of discrimination, the person who wins the lawsuit, the harm might not be very great. And let's say it's worth $30,000. That's the average. We think it's worth $30,000. That's not achieving our social goal of incentivizing anti-discrimination in the workplace. So that sort of disconnect between what people get and so punitive damages for companies, I think, can also lead to misunderstanding. On ethnography, there is not an ethnography component in this. My First Amendment stuff has some ethnography, but we did not sit in on these trials, although it would be fun. And there was another part of that question.
Jury.
Oh, yeah, I think this is a big problem in our research, actually, that we didn't talk to judges. So what I've started now is a project called, we just sort of had to stop and get the book written. But I've now gotten funding for and have collected the data. It's totally different than this. It's called Contested Constructions of Discrimination, and it's a vignette study where we randomly surveyed ordinary people, and they read these little workplace scenarios, and we say, do you think this is discrimination? Yes or no? How likely is it that this is discrimination? 1 to 7. If a judge determined that this was discrimination, do you think that would be fair? And so we're asking a national random sample of those questions, and we're asking federal judges. So I don't have the result. I have the results of the ordinary people, but we're working on our federal judge response rate. We're at about 30%, which, but once we have it, we'll have a really nice, tight, experimentally designed factorial analysis of what are because it randomly changes elements of the scenario. And so one of the scenarios is a sexual harassment scenario, and it's the variations are it's your boss, it's your coworker, or it's a subordinate. So we'll be able to see how much that matters for judges, and how much and one is like a joke, and one is rubbing your shoulders, and one is sending you pornographic emails, right? And so we do this with race, and so stay tuned.
Was something about jurors, access to jurors.
Oh, what's our jury pool like in the United States?
And if you got to interview some folks.
Oh, no, we did not interview. It's very secret, right, who the jurors are, and so we don't know.
Fragali, boa tarde. Bom, obrigado pela apresentação, pela palestra, extremamente interessante. Eu tinha duas perguntas, uma muito objetiva e uma talvez um pouco mais complicada. A muito objetiva é a reprodução de uma pergunta que já foi feita em relação ao tempo do segundo caso. O primeiro caso, você informou que durou 36 meses, eu gostaria de saber quanto tempo durou o segundo caso. A segunda pergunta, eu lhe ouvindo, vim fazendo um exercício comparativo. Né? O número de casos que foram apresentados desceram de 1.800.000 para 1.800, mais ou menos, 1.600. Né? Na litigância trabalhista no Brasil, em um ano, eu tenho 3 milhões de casos. Né? Uma unidade, por si só, recebe 1.500 a 1.700 casos. Né? Então, para fazer um sampling, para fazer um contraste entre um e o outro, fica extremamente complicado. Uma das soluções que tem sido trabalhada no Brasil é a ideia de acordos, de conciliação. Tem um movimento pela conciliação, ou seja, o estabelecimento de filtros através de acordos. O que eu fiquei me perguntando com a sua apresentação é se os casos que foram apresentados são casos que foram a julgamento. Qual é o impacto do acordo na sua perspectiva de situated justice? Ou seja, modifica a percepção das pessoas, elas convergem num determinado tipo de percepção do resultado quando elas conciliam? Então, seriam essas duas perguntas que eu queria fazer. Obrigado.
Okay. Thank you. Great questions. The Williams case took longer. As Franklin pointed out to us, the defense attorney was missing deadlines, so that was about a 4-year process. That's on the longer side of things, so the time of the Williams case is about 4, and the second question, I mean, my jaw is dropped at that many cases. So I think you definitely, incentivizing conciliation is fantastic. The EEOC continues to be underfunded, and that's where any kind of conciliation would occur in the U.S. It's taking 8 to 10 cases per office per year, and they do tend to take cases that involve more people, right? Because they want to make their impact as big as possible, right? We want to help as many workers as possible, so we're going to try to work on, well, they didn't take Walmart, but, they'll take big companies in an effort to have the biggest impact on the most workers. I think one of the, sort of methodologically, I would just say, you're going to have to draw a lot of samples and do it really well so that that whatever you're studying is representative of the whole caseload, but that. And incentivize conciliation perhaps, or one of the problems we have in the US is that there's essentially no labor movement at all, and that's another location where agreements and other kinds of laws can affect workplace environment, but it's really only about 6% of our workforce that's unionized. So I don't have a good answer for you, except to say, wow, that is a lot of data. Oh, and the 1.6 million, we modeled what happens to those people. They just sort of lose interest. We don't really know, and it's a big question for the legitimacy of the legal system. What do you have if you have 1.6 million people who think they've been discriminated against and 1,000 are going to trial? What's happening with how those people understand the law, their relationship to the government? How does that affect their civic participation? And there's not my own, but there's quite a bit of good research on how if you have a legal claim and you don't feel like it's fairly dealt with, you're far less likely to obey the law. You're far less likely to participate in democracy. And these measures are fantastic. So they have measures everything from like participating in your child's public school, right? If you've had to being willing to serve on a jury, to being willing to bring another lawsuit. And so I think I think there are legitimacy issues with a legal system that leaves that many people unserved. Oh.
First of all, I thank you for your presentation. It was very interesting, and the subject is very interesting for me. Social change through trials. And what I would like to know, normally this kind of thing, it's studied in labor law, civil rights, and what I would like to know is there any research going on in tax law, social change through tax trials, if you know about anything that has been written in this kind of field?
I think this is more, this is happening more in the law and economics world, in the empirical legal studies world. I think of myself as firmly in law and society, although I go to empirical legal studies occasionally, but it seems to me that there are more people there. But what I think is really interesting about the economic model, right, everyone's making rational decisions, and we can assume that if we have an incentive for, say, home ownership, people are going to take advantage of it. I don't see a lot of empirical research about whether or not they actually are. Like going to people who are making home purchasing decisions and trying to figure out, is the tax policy affecting your decision at all? I do know of some work around bankruptcy and how long the state is willing what kind of debt the state is willing to forgive and how long it can be until your next bankruptcy. And there is research. So in the U.S., they've tried to give credit counseling because it's not the fault of the banks that loaned you all of this money, even though you were a bad credit risk. It's because you were irresponsible with your money. So when you go to file bankruptcy, you have to go through these classes, and they've required it for like 8 years, and finally someone is studying the effect of this on like their later economic decisions, and it has very little impact. So I think that's a wide open area. I know we talked earlier about the tax history people, and Charlotte Crane at Northwestern Law School, and Ajay, but I think it's an open area that behavioral economists should be in more. And actually, one of my research professors at the American Bar Foundation with me is Austin Goolsbee, who was the chair of the Council of Economic Advisors for Obama for a couple of years. And now he's back in Chicago at University of Chicago in the ABF. And what was really fascinating to talk to him about after he had served in the White House was how little he was able to implement policy based on things that we completely know. He would say, we can have this finding in economics that everyone agrees on, and you can say to Obama, this is how this thing will work. And then it would have to go through 10 other people, PR, it would have to go through public relations and media and blah, blah. And so I think part of it also is thinking about how receptive government is to our empirical work.
Bruna?
Boa tarde a todas e todos. Professora, a senhora mencionou 2 casos de discriminação racial no mercado de trabalho. E eu queria saber se você se deparou com discriminações de gênero e se essas discriminações acabam tendo um resultado final mais benéfico para a parte que está litigando do que as raciais. Eu queria saber a diferença do tratamento para gênero e raça.
So, the difference in how I treat it?
No. The difference in how law...
in outcomes? No difference.
Yeah. No difference?
No difference. The kind of discrimination you are claiming made no difference. So, this is very formal, but I'm going to tell you what we said on our research team. Once you file a claim of discrimination, you might as well be black, right? So that's sort of, as soon as you've attacked the company, you might as well be the kind of discrimination for which this whole system was started. So maybe this doesn't translate very well. But as soon as you've attacked the company, you're all at the same level. And you're all fired, right? So 90% of these cases are terminations. Nobody is being discriminated against and going to the EEOC and keeping their job, right? So once you attack the company, they circle the wagons, and you are dead to them. What's a good Brazilian expression for "you're dead to me"? You're dead to me.
Yeah, you're screwed, right?
Yeah.
Something like that. Yeah.
So and it's actually, the idea of here's this set of tools. It's the exact same set of tools, even though the history of discrimination with your particular group is completely different. It's defended in the exact same way. The HR manager that deals with race claims also deals with sex claims. So one of the things I always asked in my interviews was, is there any kind of case that you're more afraid of? So cases are coming across your desk, and this one's a race discrimination, and this is a sex discrimination, and this is an equal pay, and this is pregnancy. Is there one that you go, oh no, they're all the same. We're going to win them all because we don't discriminate. We believe discrimination exists, but not here.